behalf of the Pump Court barristers, we've got Peter Cruickshank and we've got Dr. Michael Bowes. So thank you both. Peter is a barrister specialising in planning and environmental law. He's represented community groups as Rule 6 parties and in judicial reviews. And he's a joint editor of the Butterworths Planning and Law Service and a contributor to the Garner's Environmental Law. Dr. Michael Bowes is a full barrister just recently, so congratulations, and has extensive experience in the environment, planning, utilities, energy and water law. And he's spent the past decade working on NSIPs, which we're going to hear today is nationally significant infrastructure projects. And Peter's going to talk to us about planning inquiries and judicial reviews, followed by Michael, who will talk about NSIPs specifically and how to stop inappropriate ones. They will both talk for approximately 15 minutes each. Then we'll open the floor to questions, which we'll ask you to put in the chat. So reminder that this will be recorded, and reminder to put your questions in the chat as the event progresses. With no further ado, I will pass over to Peter. Thank you very much.
Good afternoon, everybody. Good evening, I should say. I am presenting this fresh from a court hearing this afternoon, and so long as the lights don't go off and security comes and throws me out, they've promised not to, we'll make progress. Let me just share my screen here. I'm going to share my slides. I hope everyone can see my slides. I'm now in presenter mode. I hope that's clear for everyone. All right. Good evening. So I'm going to talk about planning inquiries and judicial review. So when a planning decision is made, let's just start with the basics. When a planning decision is made by a local planning authority, and that's what I'm dealing with here, I'm dealing with decisions of local planning authorities, which by and large are your local council, although not always, but they are your local authority who make planning decisions. When decisions are made, there are a number of ways you can challenge those. So if there has been a refusal by the local planning authority, that's the LPA, of officers using their delegated powers, if a developer or an applicant has put forward an application for planning permission and it's been refused by the LPA, the developer or the applicant can apply to the planning inspectorate for an appeal of that decision. So where the local planning authority has refused the applicant's or developer's permission application, then they can appeal that decision. Similarly, the developer or applicant can appeal if the local planning authority failed to determine the application within the time limit. And thirdly, if there's a refusal by the planning committee, so this is effectively the same thing, this is local planning authority, but where it goes to elected councillors at a meeting and they refuse the decision, then after all of those matters, those first three on the slide, the developer or applicant can appeal to the planning inspectorate. Now, we'll come on to it in a minute, what that looks like, but really, this is the how, what, why of planning. Where you've got one of those three refusals there, or the fail to determination in time, if this is a big development, this is going to go to a planning inquiry, and we're talking significant local infrastructure or a large housing development, it's often going to go to a planning inquiry, okay? And that's what I'm going to talk about today. The last one on there says permission granted, all right? Now, as a community group, you may be very happy if permission is refused for something, and you might be quite cross and upset that the developer is trying to appeal to the planning inspectorate, okay? But where we come to an inquiry, that's where you can also join in as a community group, as a Rule 6 party. If, however, there's a big application that comes forward and people aren't happy with it, but the planning committee grant permission for it, that's where we come into judicial review territory, and I'll talk about that later, okay? So, and the reason for this is because there's no third-party right of appeal for to the planning inspectorate. So where you've got the local planning authority making decisions that the developer doesn't like, the applicant for permission doesn't like, they appeal that decision, and then you as a community group can be part of the appeal. But if it's permission granted, the only option for you is going to be a judicial review. All right, let's talk about this in more detail. Okay, so if the local planning authority refuse a permission, if they refuse to grant permission, either at committee or by officer, the planning officer using delegated powers, then when there's an appeal, the local planning authority have a duty to tell everyone who made representations about the application. So this is a good reason for you getting in there early with your representations, because if there is then an appeal, you'll be told. If you've made representations about it, you'll know. So people will know if things are going to go to inquiries, but it's a good reason for putting in your representations early in the early stages. Now, PINS there is a technical term that people in planning like to use. PINS means the planning inspectorate. PINS is the planning inspectorate's nickname, and PINS is the agency of the Department for Levelling Up Housing and Communities, responsible for making decisions about planning matters. So the planning inspectorate examine local plans prepared by local authorities, and they determine the planning appeals. So when a developer has their permission refused for a big tower block or 100 homes or more, they appeal to the planning inspectorate, and that's where you as a local community can come in. All right, there are 3 procedures by which that appeal can be made, and that's by written representations, hearing, or inquiry. Now, written representations and or a hearing are for the smaller scale appeals. We're talking an individual householder applying for an extension or to change the facade of their building, that sort of thing. It's not going to generate an inquiry necessarily. As the local interest grows in the case, and as the case becomes more complex, then it's likely going to go to an inquiry. And that's certainly the case where you've got the bigger applications for lots of homes, all right, on a big site. An inquiry is normally appropriate where there's a need to test evidence through formal questioning, so that's cross-examination, or where the issues are complex or there's substantial local interest. Okay, next slide. Let's just talk a little bit about procedure here. What I'm talking about and focusing on, because I think that's most helpful for the Community Planning Alliance, is inquiries, because I don't think that where there is group concern about significant development, that's going to be written representations or hearings. We're talking about inquiries, so let's focus on it. The venue will be chosen by the local planning authority. It's normally in a town hall or in the local council offices. And the way the inquiry works is over a period of time, beginning on the first day, you have opening statements from all the parties. These are prepared in writing and delivered by your advocate or your spokesperson. These are often typed, numbered paragraphs, make reference to relevant other appeal decisions that are an issue, or case law if that's relevant. And really, as an opening statement, it's a piece of written advocacy that frames for the inspector, here are the issues, this is what we've got to say about it, and here's why our case should win. It's very good, clear, persuasive opportunity to demonstrate your advocacy early. Then it's witnesses being called, and that's what the inspector's there to hear. He will hear witnesses give evidence in chief, and that means they'll have written a proof of evidence, and the advocate whether that's a representative for a community group or a barrister, will ask them to make clear to the inspector what their evidence is. Sometimes that's as simple as reading out a summary. Sometimes it's, can we go to page 2? I see you are making specific points here. Can you just explain to us what paragraph 2.6 is, 2.7? You're talking about this. What is that point? I just want to make sure the inspector's got the point. And evidence in chief is really the opportunity for you as a community group to put forward your case. Then comes the cross-examination, where you are faced, your witness is faced with being asked questions for the advocate from the other side. Now, if you are at inquiry for a community group, you will be your advocate will be cross-examining the developer's witnesses, seeking to put your case to them and seeking to understand this. I'm not going to dwell on that. We can have questions about it, but that's part of the process. There'll be a site visit in and amongst all of this, so the inspector can see what's going on. And then again, we've got closing statements. Closing statements are another very powerful piece of written advocacy. We just want to highlight their importance. Again, they should be nicely formatted, very clear, numbered paragraphs. The inquiries that I've done recently, the written advocacy, I think, is absolutely crucial, because it is a document the inspector takes away with him long after the evidence is closed, when he's writing up his decision and he thinks, oh yeah, that is actually a really good point there. There'll be cost applications if there are any, and then you have the decision. Let me deal with some golden rules of effective planning advocacy. Don't duplicate the council's case. Provide something additional. I've said there's the first point, but let me just expand on that. If a reason for refusal, so say the local planning authority have said, we're refusing this on the basis of road safety and transport issues. You don't want to have your own expert providing the same evidence, or worse, a different take on the council's evidence, because that allows the developer to say, the council say one thing, the local community group say another, neither can be correct, and therefore you should side with our case instead. It allows the developer effectively to drive a wedge between the arguments. So remember, at a planning inquiry, the local planning authority is your friend. They will be well resourced. They will have a barrister of their own. They may be a silk, a King's Counsel, and a junior. They will have experts for all of these topics. So provide something additional to what's there. Talk to the council, and don't duplicate. Remember, as I've said, keep your documents easy to read, clearly structured and concise, and there's various procedural rules and guidance which you should also consider. Now, very briefly, the legal test. This is what the inspector will consider to in reaching their decision. When a planning application is for determination, it must be determined in accordance with the development plan, unless material considerations indicate otherwise. So that's why you may know a lot about the local plan. That's why a lot of talk is made about local plan policies, because the starting point for planning permission is, what does the local policy say? However, are there material indications that say we shouldn't follow just what's in the development plan? And all of that is weighed up in the planning balance. Material considerations can include matters, obviously, such as the National Planning Policy Framework, supplementary planning documents, and evidence which points in different directions other than what the planning policies simply say. And that's why the planning balance is something that really is a matter of the inspector's judgment for them to determine, and that's why you want your advocacy to really push home the points that you want to make. All right, are you thinking of applying for Rule 6 status? Now, Rule 6 is the name given to Additional groups, it's within the planning inquiry procedure rules. It's rule number 6, which allows non-parties to the appeal, i.e. you're neither the council who've made the decision and you're not the appellant, you're another party. Rule 6 of the rules allows you to be a party to the inquiry. Make sure you apply as soon as possible after the receipt of the letter notifying you about the appeal. Are the council going to be dropping any reasons for refusal? Go and talk to them about it. Say, and this happened to me in an inquiry I was doing just before Christmas, council said, actually, we're not going to deal with the transport issue because we're wrapping it up in sustainability. So we had a discrete point about road safety that we went after, we picked up and we ran as a Rule 6 party and had our own expert. It was very effective. So go and talk to them. But if they're dropping a reason for refusal, it doesn't automatically mean you should pick it up and run with it yourself. Seek advice on the point. Are you a group already? Can you form one? That's great. That's helpful for Rule 6. Do you have witnesses? Who are you going to think about calling? Is it going to be expert witnesses who will write a formal proof of evidence, or are you going to be calling as witnesses members of the local community who can talk to a particular issue? Are you available for the CMC? CMC is the Case Management Conference. That's before the inquiry starts. You want to be present at that because the inspector will make directions there. And also think about costs, because when you become a Rule 6 party, you can face a costs decision against you in certain circumstances. So a famous example is where a parish council had a partial award of costs made against them as a Rule 6 party, because at the planning inquiry, they made a big fuss about objecting to a particular part of the development, which they had previously insisted upon. So you've got this sort of, you've got to have a costs award made against the Rule 6 party is highly unusual. It's almost, it's frankly almost never heard of, so long as you don't do something a bit crazy, such as in that case, where you have one position, then completely change your mind. The way costs are awarded is your conduct must be, first of all, it must be unreasonable. And second of all, it must cause the developer, it must cause another party, the developer or the local planning authority, to go and incur extra work. All right. So that's a whistle-stop tour through the planning inquiry process. Just going to talk very briefly about what happens when permission is granted. So here we're in judicial review territory. If the local authority grants permission, you can't appeal that decision to the planning inspectorate. All right. There's nothing that you can do as a community group to the planning inspectorate when you're not the applicant to the decision. All right. And that's why we're not in inquiry territory here when the local authority have granted permission, because you can't appeal to PINS. Your only option then is to judicial review the decision. And there's some things I'll come on to on the next slide which are really material here. But JR really asked the court to consider the lawfulness and not the merits of the decision. So you can't in your pleadings say the local authority made a choice that we don't like. We would have preferred them to have made another choice. You have to demonstrate that their choice was illegal. So it's automatically a complicated and difficult threshold. The grounds for judicial review have traditionally been characterized as illegality, irrationality, and procedural unfairness, although there's a bit of fluidity today and the three grounds blend in places. I've just listed here what some of the grounds for judicial review in planning cases often are. So this is that an officer's advice or the report that they prepared failed to take into account a relevant consideration. So, for example, if biodiversity is a massive issue and it's just not dealt with it at all, that would be a significant point. Or if it took into account irrelevant considerations so that that formed a substantive part of the reasoning, then again, that's a material point. What happens if the officer's advice, so this is at the planning committee meeting, so you've got elected councillors, they're all sitting there and saying, hang on, what about this point? I want to ask questions about that. I want to raise this issue. And if the officer gives advice that is irrational or materially misleading, similarly, if the report makes a recommendation on that basis, then that's another ground. You've got points about fettering the discretion of the committee, saying you can't consider X when they can, or you've got points about failure of a sufficient inquiry. There can be points about there being errors of law. So that's a more straightforward issue to do with not complying with legislative requirements, a bit of a technical issue. There's a ground about, quote, substantive unfairness caused by their actions. So, for example, if the local planning authority have changed the rules at short notice, or they've adopted various procedures that have meant that the whole planning application has been substantively unfair. You could argue that there's been procedural error or procedural bias, or straightforwardly that there's a mistake of fact, a material mistake of fact. So the issues in the case, as relied upon by the officer, have just been wrongly assessed. He's said we're dealing with apples when in fact it's oranges. All right. I could give some examples, but I'm mindful of the time. Maybe I'll save it for Q&A. Practicalities of JR. JR is a difficult matter for claimants to deal with on your own. It's difficult anyway. You have a 6-week time limit. So from the date the permission was granted, you have 6 weeks to file and serve a claim form, a statement of financial resources, a statement of facts and grounds, and evidence in an indexed and paginated bundle with the High Court, as well as going through pre-action protocol correspondence. It's a lot to do, and it's a difficult job to do. And the court has recognised that it is a, quote, significant, but I think, I'm pretty sure that's right. I didn't have time to double check that quote today. The court has recognised this is a significant burden on litigants. It's those words there or thereabouts, but it really is. If you're a litigant in person, you've got to do a lot within 6 weeks. And a statement of facts and grounds is not an easy document to put together. Planning law has its own language and technicalities. Looking at these grounds for judicial review, there are lots of cases, precedents, that deal with all of these points and more. And what you are asking the High Court to do is apply the intricacies of the case law of previously decided cases that are binding on the High Court against the facts of your case. And it will be technical and it will be detailed, and it will have to be at a fine and precise level of detail. So if you are thinking of a JR and you've got and you're going to a barrister to ask them to help you bring that case, please expect to be asked an awful lot of questions about it, because it really is the details that matter at a level that you might find a bit baffling, but it really comes down to very fine issues about whether or not the court can be persuaded to grant you relief. But note also, judicial review is not directly straight into a court hearing before a High Court judge. You have a further hurdle to get over, as well as the provision of all of that information there. You've got to get permission to bring your judicial review claim, and that's why often it's decided on the papers. That's called the permission stage. But say you, in your statement of facts and grounds, you have 5 different grounds. You have one about failing to take into account material consideration, several about illegality and misleading advice, one about procedural unfairness. Those are all different points, and the court might say you can proceed to judicial review on grounds 1, 3, and 4, but not your others. And it's only after you've got through permission that you go to the substantive hearing. And to get a final outcome, you really are looking at a 4 to 6 month process. The costs point is also very material, because if you are going to bring a really well argued and fiercely arguable claim, you want to claim Aarhus cost protection. There is case law that says, step back. Aarhus is the International Convention on Access to Environmental Information, but for these purposes, what it does is it provides a costs cap of £10,000, so that if you are unsuccessful with your claim, the maximum cost you will have to pay is 10 grand, 10k. So I appreciate that sounds like a lot of money, but I can assure those of you who are not used to litigation, costs can be substantively higher than that. Okay, final points. Use your funds wisely. As a community group, you will be fundraising. Think about direct access barristers. Direct access means you don't need to go through a solicitor to get the barrister, all right? You might feel if you're doing that, particularly for planning inquiries, you are paying twice. You're paying a solicitor and you're paying a barrister, and that might use up the monies that you have. When you go asking barristers what fees, or barristers' clerks, what fees they may charge to represent you at a hearing for 1 week or 2 weeks or 3 weeks or however long it is, you may be faced with an eye-wateringly high fee that may make you turn around and walk straight away. However, don't be too dissuaded by that. I think my advice would be that there are junior counsel who will assist you. If you persevere with it, you'll find good, competent junior barristers who are very good at their jobs, who will do it perhaps pro bono, i.e. for no fee at all, or I think more reasonably and more fairly for a small fee. I'll do you a 2-week planning inquiry or a 1-week planning inquiry for X £1,000, 5k maybe. So you're not looking at these vast sums of money. And the reason that the fees are charged is because it is a lot of work. When I've done planning inquiries, you are getting up at 3 or 4 in the morning as a barrister, or working late, whatever your work habits are, to master the information, make sure you've got your questions sorted, make sure your evidence is presented in the best light, writing your closing submissions. It's a lot. So there's a reason the fees are charged are high, but it need not be so eye-watering. Second point, let the evidence speak for itself. Inspectors and judges aren't going to have the wool pulled over their eyes. You want, in a trade-off between having excellent, having the best silk in the country representing you and having good expert evidence, I would say you go with good evidence every time, and that's where you should spend your money, because the inspectors are experienced and they want to know what the case is. They want to know how the expert evidence is presented. I would, that's my view. You should be giving serious consideration to using what funds you have to get paid experts who can give good expert evidence on matters such as flooding and drainage. It's really technical stuff. Or heritage, again, it's technical stuff, rather than just having a generic approach to the matter. And certainly instead of spending all of your pool of money on senior King's Counsel. But if there are any senior King's Counsel watching, they may not like me for saying so, but I think that's good advice that you should hear. Now, for judicial review, this last point I'm going to make, I think you do need a solicitor, because if you look at all of this, all of those documents that need to be put together, particularly in an indexed and paginated bundle, it's almost impossible to do on your own, all right? And to do it well, to give the court a and the other side a good, clean chance of getting off to a good start and everyone knowing what your points are, I think you want to be thinking about spending some money on a solicitor for a judicial review. I don't think necessarily the same thing applies for a planning inquiry. I think you can go direct access. All right, I think that was all I wanted to say. I'm going to stop sharing my screen now and hand over to my colleague, Michael.
Brilliant. Thank you so much. So while Michael gets his screen shared and ready, that was incredibly clear, and I love the sort of step-by-step process. The golden rules for Rule 6 party, really helpful, and how to use funds wisely was brilliant, actually. So thank you very much for that. Now, Michael, you're on mute at the moment. You may intend to be because you're sharing screen. Peter, I'm wondering what you think about trying to answer some of the questions in the chat while Michael's talking, because there are quite a few and it might save some time at the end. How does that sound?
Just noticed. Thank you.
Which is good. I think that's a sign of a good talk. Lots of questions.
I'll have a look.
Okay, thank you. If you can't, we can do them at the end. But Michael, are you having trouble?
No. Here we go.
There we go. Excellent.
Is that me sharing?
It is, but you're sharing whole screen at the moment, so that's better. Okay, and then perfect. That's working.
Wonderful.
Thank
I'm
you.
on.
Over to you. Thank you.
Right. Thank you very much. Firstly, Peter, thank you very much. Thoroughly enjoyed that. Absolutely great. This is me, and Peter and I work in the same chambers, which is 6 Pump Court Chambers. And it's a pleasure to be here today and to talk to you about something slightly different. It's nationally significant infrastructure projects, development consent orders, and I'm going to sort of talk about these. I'll start with some of the things that I've done, but before I go into that, it's very important to understand that these are very, very, very large scale projects, and they, for example, are the Lower Thames Crossing, which you might have heard about, which is the largest tunnel, I believe, which has just been given consent. I was involved in that. Also, the East-West Rail Link. So these are obviously different applicants. One is road and one is rail. Other ones I've been involved in, and I must say that some of these are at different stages. Some of them have now been given approval. Some of them are paused. Some of them have paused more permanently, so to speak. And other ones, the Heathrow West Rail Link. And the rather jolly photograph to your right is something called London Resorts, which was a DCO, which was given, which is now paused, and that was a huge theme park. And last week I was involved in what's called a development of national significance, which was in Wales, and that was the largest solar farm, and that's a proposal for that. And I was representing a community group that wanted to stop it. And I've represented community groups, interested parties, and basically all areas of the spectrum, from those who wish the proposals to go forward to those who wish to basically stop the proposals. Now, not without becoming too technical, the development consent orders are separate from the Transport and Works Act orders, which are separate again from the developments of national significance, the DNSs. The development consent orders are in a piece of legislation, the Planning Act, Transport Works Act orders, or Transport Works Act, and the DNSs are the Planning Wales Act. But fundamentally, and I think that this is important for people to realise, if you are a community or if you wish to represent a party, these form a similar set of steps, which is, very important to understand that if you think to yourself, how does this impact me, and what are the stages for this? There are various different steps, as you can see on the screen. pre-application, where a developer prepares and consults, acceptance, where the planning inspectorate checks the application, pre-examination, where you must register as an interested party, and examination, and then the decision, or the recommendation decision, and then after that, obviously, you've got judicial review. Now, these are very, very substantial pieces of legislation. Well, the orders, if they're passed, they're from legislation, and then fundamentally, the legislation empowers these orders to have certain powers which you wouldn't get under normal circumstances. And that's, for example, to compulsorily acquire land, to override normal policy. If you are an undertaker, for example, I've represented utility undertakers, then their usual powers and their usual rights are fundamentally overwritten by these types of orders because they are of national significance. They are of national importance. And that is done so that progress can get made, so that we can have large infrastructure, so that we can create large tunnels, large farms, and by farms I mean solar farms or wind farms, or you create huge or vast road or rail networks. And it's fundamentally important for a country to progress that you can have such developments. However, not everyone wants these developments. Not everyone wants these orders to progress. Not everyone believes that they should progress. And indeed, you can stop them from progressing if you know what to do. And I would say that there are tricks in the trade, and I've been dealing with these for many, many years, decades, and I used to run teams in relation to this. And I think that there are a lot of important points, and it's different if you are approaching it from the side of an applicant or if you're approaching it from the side of an interested party or a utility undertaker. Now, these are the various different parties that are involved. And you've got obviously the examining authority, you've got the case team, and then you've got within that sphere, you've got members of the public, you've got affected persons, you've got statutory parties, you've got local authorities, and it's just basically a huge type of hearing or inquiry at a very, very, very large scale. And you will find that it is extremely voluminous. It's very difficult as a group or as individuals who are not trained to do this, but it can be achieved. David can beat Goliath, I assure you, if these are happening in your backyard and you want to stop it. Because process and due process needs to be followed. It's not different. It gives people powers, but it does not bypass what is required in law. Now, if you are an organization or if you are even an individual, there are certain things that you can do if you want to fundamentally prevent these from going ahead. And that's what I'll focus on in relation to today's presentation, because it's community organizations, and I understand that a lot of the communities, for example, the one I represented last week, don't want these to go ahead. Now, there are certain things that I would suggest that you do, and I think it's better that my tips focus on those as opposed to the legal intricacies and requirements of having a DCO passed. And what I would strongly suggest that you do is have a group of individuals. Have a team. Now, how big does your team have to be? Well, it doesn't have to be any size. But if you have a group of people and you break the work up and you start to tackle this, then you are in a far stronger position. If you have got a broad team, all the better. Now, I've worked with groups that have had, for example, ecologists partnering up with old planners and dividing up that work. And what do I mean? I mean that if different individuals look at different sections of the applications and they determine that one individual is going to focus on one part, another individual is going to focus on another part, then when it comes to objecting, the objections can be far more specific. And you want the objections to be specific. For example, do you have an ornithologist? Does he know that a protected red species, for example, lapwing, are on the section of land that you don't want to be developed? If so, wonderful, wonderful. Because these are the types of individuals and this is the type of information that can prevent a development. I state that develop the team and that lawyers are not enough. Now, lawyers are not enough. And any lawyer thinks that he is enough. Quite simply, I don't think he's a good lawyer. You must incorporate the knowledge of the community, of the experts, of the individuals that you have and within the groups. And I strongly suggest that you involve all sectors of your community. How is this going to impact residents? How is this going to impact the community as a whole? Every part of the team is important. Educate each other. Work with each other. Focus on what you know. You can organize later what you do not know. And as Peter was saying, spend the community funds well. Lawyers are important, and I strongly would suggest that as Peter said, that you do incorporate lawyers at the earliest possible time, because they can direct you where best to organize yourself as a group and organize your funds. Develop a process. So by that, I mean, develop a process that you think to yourself, right, if, say, for example, you want to stop a large plant, a solar plant, wind plant, farm, whatever, then you'd have to say to yourself, right, we need to break this down. And I'm not going to go through that because it's too extensive today. We need to break this down. What are the steps in relation to doing that? But obviously there are steps and council should be involved with those steps. There are various different stages at which you can object, and I'll discuss that later. Now, I'm making a presumption here. I'm making the presumption that as a community organisation, your objective may be that you want to prevent a project, but that might not be the case. If you want to prevent a development consent order, Transport Works Act order from progressing, that's fine, but you may simply want to alter the development. And what I would suggest is if you wanted to do that, then try and collaborate that with the applicant. For example, if there is a triple SI, so a site of special scientific interest, and you are concerned that the development is going to go on to that, but you're not actually opposed to the development, then communicate that. And the applicant might actually change the proposal in relation to that. That is important. And in some circumstances, the applicants will work with you. If I were advising the applicants, which I do, then I would strongly advise that community interaction is fundamental, because that is something that is very, very important in the process. And indeed, they should be communicating with you and not just dictating what's going to happen. Communication is two ways, and that's very important. Going back to the team, what you want to do is that you want to involve your team, and you want to grow that team when necessary. Now, experts can be brought in when they are needed, and experts may change. And that goes back into your process. And for example, if you say to yourself, well, we want to object to this, what's the first thing that we want to do? And experts may be involved at an early stage or at a later stage, but I assure you that that process is time well spent. So, as an interested party, what do I suggest? I suggest that you focus on what you want to protect. Don't just focus on stopping the development, because if you focus on stopping the development, you're focusing the wrong thing. You have to focus if it is, if it is an asset that you want to protect, then you must focus on the protection of the asset. If it is a triple SI that you want to protect, then you must focus on that. You must focus on local knowledge, and you must incorporate that knowledge when you can. Gather information, and by information, I mean evidence, because evidence is very, very important if you are using that evidence to try and stop something. Do you have great crested newts? If so, where's your evidence? Are there bats? If so, where's your evidence? Do you have, for example, lapwings? If so, where's your evidence? Gather the evidence. Work in sync, work as a community, and gather all of this evidence and have a home for it. And that should be part of your process as well. Use social media to your advantage, and use it as a group, and use it to collate everything that you need to know and everything that you think will arm your defense. Treat this as a campaign, because I assure you, if you are up against a multi-billion-dollar company, they will have a campaign strategy. You have to think to yourself, how am I going to win? Because that is the only important thing. And you shall win through two reasons. One is law, the other is evidence. Let the lawyers deal with the law, but it's up to you to deal with the evidence. So communicate throughout the whole process. Communication should not just be at the start. Be organized, develop a framework, develop a plan, involve all of the interested parties. Now, by that, a lot of groups work together. In projects that I've dealt with, we've had several different groups working together, sharing information, and that can be so powerful. It can be so powerful because it can pool the resources, pool the funds, and it can pool the knowledge. And if you're pooling the knowledge, what you're having is you're having a central brain, and a central brain to not only put new information, but gather old information and assess the old information and see if that is going to be useful for your case. Do you have a case that is similar to a previous case and the previous case was successful? Has another community group stopped a DCO? Has another community group found winning arguments elsewhere? What were those winning arguments? You're only going to know this by communicating, and communicate within the groups, and importantly, communicate with your lawyer. In addition to that, and incorporating back into if there are negotiations with the applicant and it resolves your problem, then I strongly suggest that you, if it does resolve the issues that you're concerned about, then communicate with the applicants. Because remember that the communication, the negotiation with the applicant, that's important, because you might not get this stopped. And he or she, well, I shouldn't. The applicant, once they have proposed this order, might not put what you've wanted to alter and negotiate into the actual proposal. So if there are any negotiations, be sensitive to your outcome. Think about, how do I want to win? So there's a variety of issues that you have to consider when you're thinking about these large projects. The law provides a strong backbone once these are given approval. They're given legal priority and very, very, very wide and deep powers. However, these powers do not whitewash everything. You still have to consider, for example, things that are very important. And I have seen huge projects fall because they have not been given the credit that they are due, such as, is the site on a triple SI, such as, has the ecology been considered, such as, has due process been considered. All of these things have to be considered before they can be before the DCO or can be provided with approval. And that is something that you can target. If you want to target those points, which are fundamental points, you can take away a pillar. And if you take away a pillar, then everything will fall. You need to be very specific in what you focus on. So to recap, if you want to stop something, communicate at the first instance. Then you would provide relevant representations. And these representations are fundamental because they state why you are wishing to fundamentally stop the order. Then you have to focus on to what extent there has been a breach of law. Then you should focus on, for example, the ecology and compulsory purchase. For example, has ecology been, have all of the ecological issues been considered? Have all of the compulsory purchase issues been considered? And it's more nuanced because compulsory purchase has to be necessary. And then the final stage is once there's been approval, once everything's been given the go-ahead, and you still think that this should not go ahead, then there is judicial review. But what you want to do is you want to stop this at the first instance. And if you think that you've got a case and you think it's a strong case and that case focuses on one of the pillars that can prevent it, then I strongly suggest that you organize as a group, that you organize with your legal team, and you focus on how are we going to prevent this? And that could be a very small issue or it could be a very large issue. And it may be an issue that the applicant has not considered. And that's where the legal team come in to help you hone your thoughts. Well, thank you very much. That is a brief introduction how to stop these going ahead. Thoroughly enjoyed that. Thank you.
Thank you very much. And yeah, I thoroughly enjoyed that too. And actually, I'm busy fighting a huge DCO at the moment. So yeah, that was very good. And again, useful golden rules. Really important to develop a process because yeah, there's a huge amount to do, isn't there? And a huge amount of information to absorb. So Peter, thank you. I see you've done a sterling job answering the questions in the chat. I think you've answered most of the ones for you. Michael, I've got one for you, which is, do you have any tips about cumulative impact and how to use that? And that's from someone who has a lot of different projects all going in one small area. And actually, I know what he's referring to. And it's basically, there'll be 4 substations, 1 converter station, some pylons, some undergrounding, 4 other sets of undergrounding. It's a massive energy hub in Essex. So do you have any sort of top tips around cumulative impact? Are you on mute?
Can you hear me? All good? Yep. Absolutely. I think that it is very, very important to incorporate that. And it's a wonderful point because ultimately percentages add up to the whole. And that is and by that, I mean, if you have got an order which is having an impact on a percentage of an ecology or a species that is then going to be reduced, then do not underestimate how those percentages can add up. And it's very important to say that. For example, I was dealing with a situation where 3% of the UK's lapwings were going to be impacted. Now, if you know that there's 3% in place A and 2% in place B, now, all right, these decisions are made on a case-by-case basis, but you can still make the point that fundamentally, and I did make this point, fundamentally, if you are reducing these things, there is going to be a massive reduction. And all right, things have to be looked at individually, but it has to be taken as part of the whole. And if you are saying that certain developments, without being so specific, are actually an improvement to the environment, then what I would say is, then why don't you have these developments all over the place and just remove triple SIs? Why don't we just wipe them out? You know, so fundamentally things are case by case, but you can link them. And if you don't have a lawyer, or if there isn't a lawyer, you can do that, or you can get advice in relation to how to do that in a non-legal way. And I think there's also always a lot more wiggle room given to those who aren't actually lawyers in relation to tying these things up. Remember, once heard, it can't be unheard. So make the points.
Thank you. That's very useful. I've got another one here. It's slightly off topic, but should be made more on topic. And this is in relation to the Treasury Green Book. Do either of you specifically have experience of project providers either adhering to the Green Book or not adhering to the Green Book when they should do?
Michael, you're still sharing your screen, mate.
Yeah, either of you want to pick up on compulsory use of Treasury Green Book for sort of transmission providers and so on?
I'm going to leave that to Michael. It's got his name on the question.
Lucky Michael. Michael, have you disappeared? I think Michael might have dropped off, has he? Marge, can you see his name?
No,
he's there. He's
just
there.
Okay. Hi, Michael. Off. Yeah. Have you come across Treasury Green Book at all in any of your dealings?
I must say that I haven't recently, but it would be interesting to find out more about what the Treasury Green Book question was and what it related to. What I have come up with recently is other issues which are specific, and then what I would say is you just look at them specifically. Each individual case has to be considered separately.
Yeah, okay, that makes sense. You can't sort of generalize across the board.
Yep.
Okay, brilliant. Thank you. Right, we are running out of time. I think we might find one more question. And actually, we might as well follow on with the cumulative impact one. So we were told by a developer that the first developer to complete their project doesn't need to consider the other developments where cumulative impact is concerned. Is that true? It's a good question. I'll throw that back at Michael.
Yeah, can you see that? Can you see that question again?
Yeah, so somebody in the chat has put they were told by a developer that the first developer to complete their project doesn't need to consider the other developments where cumulative impact is concerned. Is that true?
No.
No.
Yeah, I mean, I don't know why, because I think that fundamentally it's sort of chicken and egg, isn't it? Really, because you can't have a race to the finish line. Where the finish line keeps moving, and ultimately then you would just have people, you know, throwing up tarpaulins saying, well, that's the development finished. I mean, it then becomes ridiculous. It then becomes preposterous.
Yeah.
I mean, there would be a strong argument against that. Yeah.
Okay, so that would be one to make basically with the planning inspector, wouldn't it? Further down the line, whatever. Don't. I think what I'm taking of that is don't take what a developer says at face value, which I would certainly personally recognise for a number of projects. Okay, thank you. Good. Caroline, just checking. Are there any major questions I've missed in there? I think most of them have been answered, haven't they, on the way through?
Yep, can you hear me? There was one about somebody asked if there was the ability to have access to the land to get samples or data, which is I guess it's a legal question about whether you can go on to collect the data or not, but it was nonetheless a question.
Yeah, this came up as an issue in an inquiry I did in December, where part of the issue was to do with best and most versatile agricultural land and how that's managed, and whether or not in the relevant site people could get samples. The simple answer is try and get permission. If you're a Rule 6 party, I think it's perfectly feasible that you can say, we want to have an expert on this topic, and we would like, please, reasonable access to the land to take a soil sample or to do our own survey. And I don't think that can be refused. I think you should tread carefully if you are minded to not seek permission and just march on and just carry on anyway. I think, yeah, have a discussion with your group and your colleagues, and indeed your legal advice.
Just to add to that, Peter, in a lot of green areas there are public rights of way, either designated or undesignated, and what we've told people in our area when they've been looking to do various things is to stick to those public rights of way, both designated and undesignated. So don't know if that would apply to others as well.
Yeah, thank you, Marge. I think that's very sensible. Yes.
Okay. Well, thank you. We're past 6 o'clock. I thought that was brilliant. Really, really helpful from both of you. Thank you. Incredibly sort of practical, step by step. Lots of useful things we can all bear in mind. So really, really valuable evening. Thank you. And maybe we'll have to get you back next year when the dust, or this year later when the dust has settled on the planning and infrastructure bill. All the changes that brings about. So yeah. Huge thank you, and we've had a great turnout for this, and I know lots of people watch it on the YouTube channel once it's up there, so thank you.
You're most welcome, and I think Michael and I have both provided our details. If people would like to get in touch with us and discuss individual cases, we very much encourage you to do so. And thanks everyone for your time, and thank you to you all for having us. That's really great.
Absolute pleasure. Thank you.
Pleasure.
Right. Good night, everyone. Bye-bye. Thank you. Bye. Bye.
Thank you. Bye.